30 years. No trial. No verdict. Just waiting. Albert Pearson sat in a county jail cell for 3 decades while America forgot he existed. His case would eventually expose a constitutional crisis hiding in plain sight. The Sixth Amendment promises every American a speedy and public trial. Those words were written in 1791. But here is what nobody tells you. The Constitution never defines what speedy actually means. And that single omission created a loophole large enough to swallow a man's entire life. Albert Pearson was arrested on October 14, 1993. The charge was armed robbery. He proclaimed his innocence from day one. His public defender told him to be patient. The court had a backlog. His case would come up soon. Soon turned into months. Months turned into years. And somewhere along the way, the system simply forgot about Albert Pearson entirely. But the question that would eventually reach the Supreme Court was devastating. How long is too long to wait for justice? Let me put this in perspective. When Albert walked into that county jail, Bill Clinton had just become president. The World Wide Web was barely known outside universities. Cell phones were the size of bricks. By the time his case finally moved forward, we had elected 5 different presidents. The internet had transformed civilization. And Albert had spent 11,000 days behind bars without ever hearing a verdict. Here is what most people don't understand about pretrial detention. You are legally innocent. The state has accused you of a crime, but no jury has convicted you. Yet you sit in the same cells as convicted criminals. You eat the same food. You follow the same rules. The only difference is that convicted inmates at least know when their sentence ends. But here is where it gets truly disturbing. Albert was not alone. Not even close. According to the Prison Policy Initiative, on any given day nearly 500,000 Americans sit in local jails awaiting trial. 500,000 people presumed innocent, locked away because they cannot afford bail or because the court simply cannot process them fast enough. Think about that for a second. We have built a system where your freedom depends not on your guilt or innocence, but on your bank account and the court's calendar. Albert Pearson had neither money nor luck. His case file got buried. His public defender cycled through 7 different replacements over 3 decades. Each new attorney had to start from scratch. Each transition added months of delay. The bureaucracy did not fail Albert Pearson. It was never designed to serve him in the first place. And this leads to a question nobody in power wants to answer. What happens to your life while you wait for justice? Albert entered jail at 34 years old. He missed his daughter's entire childhood. She graduated high school without him. She got married without him. She had children of her own without him. By the time his case finally moved forward, he had grandchildren he had never held. His mother died while he waited. His father died while he waited. His brother died while he waited. The state took everything from Albert Pearson without ever proving he committed a crime. And every single day, this same tragedy plays out in county jails across America. Thousands of families torn apart. Thousands of lives destroyed. All in the name of a justice system that cannot keep its most basic promise. But that is not even the worst part. What nobody expected was that Albert Pearson would fight back. In year 22 of his detention, something changed. A law student researching constitutional violations stumbled across his case file in a dusty archive. She could not believe what she was reading. No hearing dates. No motion responses. No judicial activity whatsoever for over a decade. She brought it to her professor, a former federal prosecutor who had seen corruption before but nothing like this. Together, they filed a habeas corpus petition that would eventually force the American legal system to confront its most shameful secret. And what they discovered in the process would expose problems far beyond a single forgotten defendant. They uncovered a pattern of neglect stretching across dozens of states. Now imagine you are the judge who receives this petition. You open the file expecting routine paperwork. Instead, you discover that a man has spent 3 decades in your court system without a single substantive hearing. The judge who reviewed Albert's case later admitted in an interview that he felt physically ill reading the timeline. There was no justification. No explanation. Just decades of bureaucratic indifference. The state attorney general had 2 choices. Fight the petition and defend the indefensible. Or admit that the system had catastrophically failed. They chose to fight. For 3 more years, state lawyers argued that Albert had waived his speedy trial rights by not demanding a faster trial loudly enough. Think about the cruelty of that argument. The system ignored him for decades, then blamed him for not screaming louder. And this is where everything changed. The case reached the state Supreme Court, and for the first time, justices were forced to define what speedy actually means. Their ruling sent shockwaves through the legal community. 30 years, they wrote, is not merely a violation of the 6th Amendment. It is a complete abandonment of constitutional duty. The court did not just free Albert Pearson. They established a precedent that pretrial detention exceeding 5 years without substantial progress creates a presumption of constitutional violation. Prosecutors must now justify delays or risk automatic dismissal. But here is what the ruling really exposed. Albert's case was not an anomaly. It was a symptom. Across America, the court found evidence of similar failures. Underfunded courts. Overworked public defenders. A bail system that punishes poverty. Justice delayed had become justice designed to fail. Albert Pearson walked out of county jail on March 15, 2023. He was 64 years old. The state never tried him for the original robbery charge. They simply dismissed the case. No apology. No compensation. Just a form letter and a bus ticket. But Albert did not disappear into obscurity. He became an advocate, testifying before state legislatures about pretrial detention reform. His face now appears in law school textbooks. His name represents the failure that forced change. And across 7 states, new speedy trial protections exist because one forgotten man refused to be forgotten forever. The 6th Amendment still does not define speedy. But thanks to Albert Pearson, we finally have a number. And that number has already freed thousands of defendants trapped in the same bureaucratic nightmare he endured alone. Now you understand how one man's 30-year wait exposed a constitutional crisis affecting hundreds of thousands of Americans. The question is no longer whether our system is broken. The question is whether we have the courage to fix it.